Facebook to load up. Okay, we're live. Are you a producer? Are you a designer? Are you a gaffer? Are you a sound designer? If you've listened to all these professional titles, you'll hear something in common with all of them. All of these professional titles are behind the scenes, basically not at the forefront, basically not being the actor, the singer, the dancer, or whatever you would think is a professional title for an artist. All of these people are behind the scenes, and all of these people can apply for the artist visa, because the artist visa is not only for people who are actors, etc. It's for all creative people. Hi, everybody. I'm Elektra. I'm the artist visa lawyer. I'm located here in the heart of New York City, the arts capital of the world. And I go live every day to talk to you about all things related to artist visas and artist green cards. And today I want to talk about people who are behind the scenes, just like those professional titles that I mentioned to you, people who are sound designers, lighting designers, product designers. All of these professional titles qualify to file under the artist visa. And if you qualify and you meet the requirements, you can get the artist visa, which is less restrictive than the O-1A, which has restrictions in terms of your employment. So let's talk about product designers. I really love product designers. They're one of my favorite professional artists to work on. And I love them because almost all of my product design consultations kind of start off with the potential client reading off the qualifications for the O-1A. Now, an O-1, a product designer may very well qualify for the O-1A. And if he or she does, then he or she can file for the O-1A. I don't know what would be the benefit of filing an O-1A because it is so restrictive. Remember, the biggest difference between O-1A versus O-1B is your ability to add employment, projects, jobs, gigs, post approval. So I like them because they seem to think that because they design products and because they're designers, that they automatically qualify under the more austere O-1A. Not at all true. I'm here to dispel that. O-1Bs can also include product designers. And in fact, I only file them as O-1Bs. So basically, if you are a product designer, you're behind the scenes, you're designing robots. We had a client who designed robots, we got approved. We had a client who designed packaging who was approved. You can file under the O-1B. Now, of course, a lot of this is going to depend on the quality of your evidence, right? It's going to depend on what the evidence looks like, what your day-to-day looks like. But I have yet to have represented a product designer that I have filed under O-1A. That doesn't mean I don't file them under, it doesn't mean that O-1A product designers don't exist. It just means that in our law firm, we see the creativity, see the artistry in product designers, and therefore we file them under O-1Bs, which allow them to continue to expand upon that. Because one of the things that the O-1B is very unique for is this ability to add multiple jobs post approval. This, I want to repeat, is very unique. This basically means that when you're filing your petition, you get approved, and then you get other offers during your O-1 approval, you can accept them. This means that you don't need to go back to USCIS and let them know, like, hey, I'm going to file a new petition because I got a new job. You don't need to do that at all. There's no recording requirement on your end. You don't need to notate down all the additional jobs that you've gotten. You can if you want to, right? And that's based on you and your how you like to organize your work. But is it a legal requirement? No. Is it something that you must do in order to maintain your status? No. So this is why we file product designers and essentially anybody who uses artistry and creativity in the work that they do under O-1B, because that allows you freedom. This allows you the freedom to accept other jobs as long as it's within your field. This allows you the freedom to explore your creativity, expand upon your creativity, grow as an artist without being stunted by working for one company, right? A lot of the times, and I think this is actually very common now, lots of folks are going from company to company to project because the nature of the world right now is not to be so static, right? Is not to be so pigeonholed and stuck in one position. You want, especially as an artist, you want that freedom. In fact, I would argue that you need that freedom to be a successful artist. I'm not sure of any of the top major artists that have pretty much stuck to one job or one project or one series. I mean, you just don't do that, because that's not what the nature of what an artist is. Somebody on TikTok, Alex Lallman. Hi, I have a question. What's your question, Alex? I'm happy to respond if I know the answer, but if you don't type it, I won't be able to help you. But if you have a question, type it in. If you have a question on Instagram, if you have a question on Facebook, type your question and hopefully I'll be able to answer it and provide you with some information. But essentially what I'm trying to say is if you are behind the scenes, if you are a choreographer, if you are somebody that is an editor, you edit films, if you are somebody that is a producer, right? You're not acting within the film, you're not doing anything within the theater production, you're the one making it all happen as the producer, the director, the stage manager. Stage managers of theater productions can absolutely qualify for the O-1B, and I have done multiple of them. I love stage managers. They're indispensable to the success of a production. So if you are behind the scenes, you are not at all precluded from filing for the O-1B. You can absolutely file for the O-1B, and hopefully qualify if you meet the requirements. So Alex asked, I was married to a U.S. citizen. I got my 2-year green card divorce and filed I-751 divorce for extreme cruelty. I'm sorry to hear about your divorce, but yes, that is definitely a way to get a green card. I mostly focus on green cards for those who are artists, or those who are artists and who get married to a U.S. citizen. So I just got my 10-year green card. When can I file for citizenship? So I actually cannot give you that answer. I don't know any dates associated with your petition. So if you want very personalized information with regards to your situation, the best thing to do is consult with a licensed immigration attorney. I don't know dates, so I can't advise you. And I can't provide you with that information. I'm sorry, Alex. But if you have questions with regards to the O-1, the artist visa, or the artist green card, which is what I'm focused on as an immigration attorney, then we can talk more about that. But as I was saying, stage managers, producers, why don't you guys write down in the comments any behind the scenes professions that you can think of? SEO specialists, a lot of the times SEO specialists are filed under O-1A. Not in our firm, we file them under O-1B. So someone who is looking at keywords, who's advising on the best language to use when writing, that is absolutely creative strategy that is being employed. That is exactly what a writer does. And writers are filed under O-1Bs, whether it is a playwright, a screenwriter, a journalist, a traditional novelist, we file them under O-1Bs. So there's nothing that precludes you from filing as an O-1B, an artist. Now, the difficulty with filing as an O-1B, so Emmanuel Jeremiah, please can you talk about a musical artist and upcoming with 2 singles released on all platforms and content creator with 700K followers on Facebook? So those are people who would not be behind the scenes, right? So musical artists, we do them all the time. If you're trying to ask me if a 2 single release is enough to qualify, probably not. You would need more because there's 3 criteria that you need to meet on all platforms and content creators with 700K followers on Facebook. So content creator, we do them all the time. We do them whether or not they're influencers. So we represent major influencers. You can go on our website, you'll see she's very, very famous on TikTok. And content creators such as micro influencers who have like 2 to 3K followers, and content creators, basically those marketing specialists who create content for brands and companies or agencies that they work with. All of them qualify for O-1. I'm not sure what your question is. You don't need 2 single releases to qualify. If you did, that's great, but we have many musicians and vocalists who don't have releases at all, who don't even have great Spotify numbers. And again, with content creators, with Facebook, Facebook is not really in the O-1 world enough to qualify as a content creator, especially because of the algorithm on Facebook, and especially because with Facebook, it's easier to buy followers compared to other platforms. So it's not the only thing. If you're going to use Facebook in isolation, I would not think that that was great strategy. If you're going to really want to file as an influencer or content creator, you're going to need to have more of the newer platforms. So OnlyFans, for example, Instagram, TikTok, etc. So yeah, I hope that helps. So what I was saying earlier about the difficulty of filing as a behind the scenes person and even as a content creator is press. So a lot of the times when you are behind the scenes, you're not necessarily going to have press articles about you. It's not that you're not worthy of a press article. It's just that in the way press works, they tend to focus and highlight people who are on stage, right? That's what a lot of the times people write about. But does that mean that because in the industry of writing and in your industry, they don't talk about people behind the scenes, that resolves your responsibility of getting press? No, absolutely not. It doesn't matter what the industry norms are. Immigration does not care. They want you to have press. This is something that is very important to them in the adjudication of the petition. So I'll give you an example. I'm working on a green card RFE, very strong case. And this person got an RFE for her press articles. Mind you, a strong EB1A, a strong green card case is about 20 to 25 articles. And this person had 37. So way more than what I consider to be a strong EB1A petition. So you cannot escape from press. If you don't have press, then you're not really filing what could be considered a strong case. You need to get press. Press is something that is important. It does not matter what your industry norm is. So if you're like, hey, producers don't get press, it doesn't matter. I hate to be the bearer of bad news, but it really does not matter what the industry norms are like. So let's go to content creators and influencers. We represent a lot of influencers. And in the influencer world, typically contracts will go through the agency that represents the influencer, and then the funds will go to the client. It doesn't matter, the influencer. It doesn't matter if that's what the industry norm is, if that's what happens. USCIS needs to see contracts, meaning they need to see proof of your future work. So if you do not have proof of future work, if you do not have brands that are willing to sign a document with you confirming that they will be working with you, then you're not going to be able to file the case, no matter how many followers you have. I once did a consultation with somebody who was an influencer, like a travel influencer, who was one of the biggest Africa-based travel influencers and huge following. I mean, great following. However, he was categoric about not being able to get anybody to sign future work. So it doesn't matter if you have 1 million followers. If you cannot prove future work, then it's never going to happen, right? You're not going to be able to file a petition because there will be no basis for your O-1. There will be no basis to identify the O-1 validity period. There will be no basis to understand what your future distinguished engagements are, what your future distinguished organizations are. All of that information is localized within the contract. So those are some of the difficulties with regards to how to resolve industry norms with what the government is requiring of us for a successful petition. Now, the only way to resolve this, unfortunately, is to give the government what they want. I mean, like I said, it doesn't matter what the industry norms are. And again, it depends on the industry. Some industries are way more difficult than others. The theater industry, the performance industry, acting, modeling. In the modeling world, things are very fast. We used to represent a major modeling agency, and for them, it was just like, listen, Elektra, I can't confirm anything because models will get jobs one day and then book another. I mean, it just happens so quickly. But immigration doesn't care. They want to see your work planned out for the next 3 years. So you have to get that cemented, and you have to make sure that there are people who want to work with you because they need to sign these documents. So those are like the biggest difficulties that I see with regards to people behind the scenes. Their lack of press, because it's again not an industry norm for somebody who's behind the scenes to get press. And number two, with respect to product designers, some of the times, just like actors and models, etc., it's actually hard to confirm who's going to want to work with you for the next 3 years. And I would add that that is very difficult for everybody, right? I mean, it's very hard, even for us. It's even hard for me to say, hey, in the next 3 years, I'm going to be working with X, Y, and Z. I mean, it doesn't happen like that. I can make predictions or educated guesses based on my past work, but I really cannot say with certainty which profession I'm going to be representing. So I have that difficulty as well. And I empathize. I really understand. But we file artist visa cases exclusively, and we have clients who are able to secure that future work. So I would say if you're going to book a consultation with me or with any other attorney, it would be a waste of your money to try to say, hey, I can't get future work. You should already be thinking about who your future work is going to be when you go into the consultation, so that the consultation is more about strategy instead of me trying to tell you like, hey, I understand and I empathize, but this is the law. This is what you need to do. And I don't want to waste anybody's time during the consultation, because I understand that you're paying money, you're paying your hard-earned money to speak to me or to speak to any other attorney. So you want to make sure that you get the most value for the call. And to get the most value for the call, it's not to really give pushback on what is a requirement and how difficult it might be for you to meet that requirement. The consultations should be more like strategy or for clarification on what you need for the O-1, right? My talks online, they're just very generalized talks. But in order to get more knowledge on what a specific criterion means, right? Especially future work, because like I say in my consultations, it's both technical and substantive, right? And I break that down, like what is the importance of future work other than it being a requirement? Why is it necessary? Et cetera, et cetera. But behind the scenes, people, don't be afraid. You can absolutely file for the O-1B. Even people who are like managers, even people who are like music coordinators, even people who are agents. I mean, all of these are professional endeavors, so they can absolutely apply. Who are some other people? Like, I love to do nail techs. I love to do makeup artists. I love to do tattoo artists. All of you who are nail techs, hairstylists, hair colorists, all of this is creative. All of this is artistic. You can absolutely file. Tattoo artists, you can file as well. But sometimes, again, another difficulty with tattoo artists, another difficulty with makeup artists, nail artists, is this press component. So you have to be recognized for your work in press, right? It's like no going around it. I don't know how to make it more clear, right? You want to make sure that you meet the requirements, especially with the new administration. You want to make sure that you've got those criteria, right? That you meet those criteria so that you are able to try to get the O-1, because I'm sure that you want to work as a tattoo artist, as a makeup artist, and I'm sure you want those benefits. And like a really cool thing about visa petitions with regards to the O-1 is there's something called the Yates memo, which means that once you are approved for the O-1, when you file your extension, it's by no means easier. By no means easier, guys. It's the same sort of process. However, we do have a rule on our side that states that your prior approval is prima facie evidence that this next petition should be approved. Now, again, does not mean the process is easier. It is not easier at all. We file extensions all the time, and for all intents and purposes, they are treated like fresh cases, just because We do not want you to get an RFE. We want to craft the strongest petition for you. But there is a rule on our side that allows for the officer, or not allows for the officer actually needs to defer to the prior approval in order to conduct his or her analysis for the extension approval. So that is something that is, I think, really, really important and really, really great for O-1 petitions. But you want to, I would say it's like, sometimes I have clients who are like, oh, okay, I'm not going to file with multiple jobs. I can't find multiple jobs. Let me just file with one job. Okay, fine, no problem. We'll file with one job. However, just kind of like everything in life, if you do the hard work now, if you seek out the multiple jobs now, and then you get your approval, you do not need to come back to me or any other lawyer or submit a petition to USCIS for an amendment. If you file with one job, guess what? And you get another job offer, or you want to expand your work, you're going to need to file an amendment. You're going to need to file an amendment to allow you to do that additional work. So it's better to put the hard work in now, find those multiple sources of income or multiple sources of people who want to work with you. That way, once you get approved, you're free and clear to do your work and add additional work as you move forward within your O-1. So if you're watching and you're like unsure like where to start, you're like, oh my God, this is like way too much information. This is too intense. Like, I don't even know where to start. This is all mumbo jumbo. Think about press. Press is a recognition of your work. And this is not even a USCIS thing, guys. This is not even an immigration thing. Usually people who do work at a high level, which is what the O-1 is asking for, work at a high level, tend to be recognized for their work. Not always. I'm not saying that if you're an artist and you're not recognized for work, you're not a great artist or you're not doing great work. I'm not saying that. What I'm saying is the logic that USCIS is following is if you are doing work at a high level, you will be recognized for your work in press. So try to adopt that reasoning, because even in real life, it happens. Even in real life, you'll read about people who are recognized for their achievements and their accomplishments and the work that they have done, right? When we read about celebrities, when we read about other artists, when we read about politicians, that is a form of recognition for the work that they have done. And you should have the same, because that is kind of the logic that USAS is following. The same idea with the future work. So if you are working at a high level, chances are people are going to want to work with you, which is why this future work component should not come as a surprise, because people who are producing work at a high level, people tend to want to work with you and collaborate with you and utilize your services, right? You tend to be in demand. Not that you need to be in demand. Sometimes like the reverse is not true. Like, I'm not saying that A plus B is the same as B plus A, right? I'm not saying that. I'm just trying to help you with a framework to understand what it is that USCIS is looking for when they are making a decision on your case. And more than that, it's also kind of like a cheat sheet on like how to approach your O-1 even before you come for a consult, right? For when you're coming for a consultation, the question should be like, okay, Elektra, what is going to be the process with my case, right? What are things that we're going to be doing within my petition, as opposed to why do I need future work? Or as opposed to, I don't have press, what should I do, right? You know what you need to do. You need to get press, right? It is something that they are looking for in terms of making the decision within your petition. And especially if you have long-term aspirations, if you have an aspiration to live in the US long-term and you're like, I don't want to file an artist visa every 3 years. I want to get my artist green card. You definitely need press, right? It's like no escaping. You definitely need press. You definitely need that form of recognition and more forms of recognition. So I always think of the O-1 as kind of like your plan for your career. I know it sucks because a lot of artists and creative people, they don't look at certain recognitions and achievements as part of an overarching marketing and business strategy. But in the real world, you should, right? In the real world, you should, and also in the O-1, you must. So in the O-1 world, you have to. In the business world, I would encourage you to do so. But the whole point of today's talk was to kind of talk about behind the scenes people and whether or not they can do the artist visa. Now, the artist visa is open to anyone that is using artistry and creativity in the work that he or she is doing. And the O-1 visa is for people who are also behind the scenes. So tattoo artists, makeup artists, nail artists, producers, stage managers, editors, sound techs, lighting designers, designers, all types of designers, graphic designers, UX designers, UI designers. We have done all of them. I have done, many, many, many types of artistic professionals and creative professionals. So all of you guys can potentially file for the O-1. To know whether or not you qualify, you meet the requirements for the O-1, you would have to have a consultation to further discuss. So I will be live every day. If you've got questions, comments, feel free to send me a message. I'm happy to answer questions during a live. And if you have anything that is unclear, send a message. I love talking about these things. I love talking about all nuances and subtleties of the O-1. So please continue to like and follow and comment. And I will see you guys tomorrow. Bye, everybody.